Good morning. My name is Tom Hartmann with the Hartmann Law Firm in Watchung, New Jersey. Today I wanted to talk to you about the importance of deciding whether a worker is an employee or an independent contractor. That decision has critical implications both for the worker and the company because it helps you decide who's paying taxes, who's withholding taxes, who's receiving benefits, retirement benefits, medical benefits, etc. And those things have great importance to both the worker and the company, financial implications and long-term benefit implications. At a very high level, the Internal Revenue Service or the New Jersey Department of Revenue or various other state agencies or contracting authorities look at who's got control and what level of control is there over the worker. The more control that the company has over the worker, the more likely it is that the court or the Internal Revenue Service will determine that there was an employment relationship and the person is an employee. And that means that the company should pay benefits, should withhold taxes, should pay portions of Social Security tax and unemployment tax for the benefit of the employee. On the other hand, if the person provides his or own tools, has other customers, decides when to come to work, has his or her own separate work location, then it's more likely that the person is an independent contractor. The courts also look at the duration of the relationship. If you've been an independent contractor working exclusively for one company and you've been doing it for 5 or 10 years, it's more likely that the courts or the Internal Revenue Service will say, wait a minute, we think that's an employment relationship, even though you've called it a contractor relationship. It is important as to the intention of the parties. So you put that down in writing, you send emails, or you put something down in a written agreement. But even the intention can be overwritten by the facts. The New Jersey Supreme Court this year decided a case in 2015 that laid out 12 factors to evaluate. The United States Internal Revenue Service has at various times looked at between 12 and 20 factors to decide whether someone is a contractor or an employee. But the key, the most important factor is the level of control. The more control, the more authority that is exercised by the company over the individual, over the worker, the more likely it is that the person is an employee as opposed to a contractor. And while you may not always have an employment agreement, if you're a company, you may not always have an employment agreement with your employees because you want to be able to deal with them in an at-will status. If you have somebody who's an independent contractor, it's very important that you have an agreement in place, an independent contractor agreement, a consulting agreement, a management services agreement, something along those lines that says what the responsibilities of each party are and making sure that it's clear that we think you are and you think you are an independent contractor, therefore we're not withholding taxes, we're not paying benefits, we're not accruing retirement for you. It's a very important decision. And if you make the wrong decision, then the IRS and various other parties can come back and say, okay, we're going to, number one, relook at this, and if we come to a different conclusion, they're going to unravel all that went on over the years and reevaluate who's got to pay taxes, how much taxes have to be paid, what benefits have to be accrued, and all that sort of thing. So it's very important that you look at this carefully with your eyes open and avoid any ambiguity so that there is clarity and the ability to avoid litigation. The Hartmann Law Firm is located in Watchung, New Jersey. Our telephone number is 908-769-6888, and we are glad to help you or your company, whether you're a contractor and an employee or the company. We are glad to assist you with this in any manner. Thank you very much.